Imagine someone telling you that you can't use the bathroom or other gender-segregated public facilities you psychologically identify with. They say that your presence makes others feel unsafe and uncomfortable, belittling you to feel unwanted and unaccepted. Although your comfort in using the women's or men's restroom or locker room seems natural and innate to you, it seems to be sparking heated national debates and endless battles within the court system. There is established legislation protecting members of communities based on sex and race, but why not specifically gender? Members of the transgender community need to be properly represented and protected in legislation. Many facets of research have expressed that members of the transgender community aren't holistically protected under anti-discriminatory law. In a 2007 issue of the UPenn Journal of Constitutional Law, University of Pennsylvania law scholar and Juris Doctorate candidate Diana Elkind expressed, "The court has been reluctant to recognize a broader definition of gender for purposes of categorizing sexual minorities within the heightened protection granted under the 14th Amendment." After analyzing and evaluating both popular and scholarly articles regarding the topic of transgender rights, I have concluded that new legislation should be enforced or existing legislation should be modified in a manner that doesn't leave the protection of members of the transgender community from discrimination up for interpretation by the court system or members of the public. Similar to how Washington Post journalist Amber Phillips has conveyed, the chief problem stems from the fact that current legislation allows for interpretation by the courts and amongst members of the general public regarding whether it is illegal to discriminate against members of the transgender community in public arenas like schools. Some argue and interpret legislation in a way that deems this discrimination illegal, while others gauge it as being legal because the law is merely not clear. The trend of contradictory interpretations of anti-discriminatory law is most prominently seen in court case settlements. In a Washington Post article posted on the 9th of May in 2016, reporter Amber Phillips stated, "Virginia Federal Appeals Court ruled in favor of transgender Virginia high school student Gavin Grimm, saying he can sue his school board for discrimination because it banned him from the boys' bathroom. In making its decision, the court cited the Department of Education's interpretation of gender discrimination." On the 13th of May, President Obama issued a directive in which, according to a Fox News Network post on June 2, 2016, the federal government told public schools they must allow transgender students to use bathrooms that correspond with their gender identity rather than the gender listed on their birth certificate. However, some argue that the president's directive is stretching the law further than it was meant to go. They believe that directives like these are not properly enforcing legislation like Title VI, for it expresses that it is not considered discrimination to allocate distinct bathrooms in locker rooms that separate men from women in these private and sensitive settings. According to the governor of the state of North Carolina, in response to Obama's directive, the Justice Department is making law for the federal government as opposed to enforcing it. Unfortunately, a number of states, including Ohio, Nebraska, and Michigan, agree with McQuarrie and are actually suing the Obama administration through the U.S. District Court for his directive. Elkind pays close attention to why gaining desired access to public restrooms is essential to the transgender community in order to instill a sense of liberty, comfort, and safety. According to Elkind, the bathroom conflict is the next frontier of equality for the transgender community. Moreover, the final section of Elkind's piece presents successful models like the New York and San Francisco regulations that pave the road for protection for the members of the transgender community at the national level. The components that make more small-scale protection, like the New York civil rights law, successful in protecting transgendered individuals, include their specification of the term gender as one that pertains to a person's gender identity, self-image, appearance, behavior, or expression, whether or not it's different from that traditionally associated with the legal sex assigned to that person at birth. Organizations like the New York Civil Liberties Union and their promotion of legislation like the Gender Expression Not Discrimination Act are what inspired the amendments to the New York civil rights law. According to a 2012 report issued by the NICLU, GENDA would fix this problem by adding gender identity and gender expression to the categories currently included in the New York State's anti-discrimination laws. Ross Amato examined Minnesota's anti-discrimination law, the Minnesota Human Rights Act, and evaluated its inclusiveness utilizing the Goins v. West Group Incorporated case. In this particular case, the Supreme Court interpreted the MHRA in a manner that allowed for a transgendered individual's employer to have full power over deciding which bathroom she is eligible to use, which is outrageously discriminatory towards the transgendered employee. According to a 2002 issue of the William Mitchell Law Review, law scholar Ross Amato explains West Group distinguished Goins on the basis that Goins failed to conform to the stereotypical view of a woman using the women's restroom, and that because this mistreatment is permitted, the tenets of the MHRA have not been upheld. In regards to another case, Ulane versus Eastern Airlines Incorporated, the courts are solely focusing on upholding discrimination based on sex versus discrimination based on gender, which is why the courts in the West Group case claim that it is a long shot to interpret Title VII and MHRA as legislature that protects transgendered individuals. However, according to Ross Amato, the New Jersey court interpreted Price Waterhouse versus Hopkins to mean that the U.S. Supreme Court had determined that the word sex in Title VII encompasses both concepts of sex and gender. The interpretations are not consistent, so anti-discrimination legislature, like the MHRA, should be modified to clearly include members of the transgender community by emphasizing not only anti-discrimination towards sex, but also towards gender. Daniela Schmidt, a University of Michigan law school scholar, agrees with researchers like Ross Amato that express that some existing legislature should be modified in a manner that includes and respectively protects transgendered folks. Fortunately, after a thorough analysis of existing legislation, Schmidt was able to find a possible solution. According to a 2013 issue of the Michigan Journal of Gender and Law, Schmidt conveys state laws that prohibit discrimination on the basis of disability might offer a winning alternative argument for the legal protection of trans people. Schmidt offers a potential loophole to utilize against the courts if legislature is not modified to holistically protect the members of the transgender community. The meat of this argument derives from the fact that once it has been established that there is a legally cognizable disability involved, the trans employee is, according to Schmidt, then entitled to request accommodation for this disability from his or her employer. Duke University law scholar and Juris Doctor candidate Lauren Sanders also discusses existing resources that can be modified to provide more protection and freedom to the members of the transgender community. Sanders first delves into how the National Center for Transgender Equality and the National Gay and Lesbian Task Force's 2011 survey displayed results that conveyed that members of the transgender community are, according to Sanders' 2016 issue of the Duke Journal of Gender Law and Policy, likely to live in extreme poverty, or 4 times more likely to have a household income of less than $10,000 per year than the general population. The results also indicate that the unemployment rate within the transgender community is twice as high as the general population unemployment rate. It additionally revealed that the discrimination in the workplace is considered a near universal experience for members of the transgender community. Groups like the Equal Employment Opportunity Commission promote the interpretation of Title VII's disallowance of discrimination based on sex to include individuals who identify as transgender. In fact, according to Sanders, the EEOC plays a pivotal role in making legislative change by ensuring employers' compliance with this interpretation of Title VII. EEOC's interpretation of Title VII may create an impetus for recognition of transgender employment rights by the federal courts. After examining multiple sides of research upon the topic, I have come to the conclusion that there are 2 possible solutions that can be implemented in order to resolve the issue of leaving those who discriminate against members of the transgender community unpunished under the law. My first proposed amendment is to implement nationally withheld legislation that clearly asserts that discrimination towards transgendered individuals is unlawful. My second proposed solution involves modifying existing legislation in order to clearly establish the protection of transgendered individuals under the law. The most effective route to establishing nationally withheld legislation that clearly protects members of the transgender community will be through implementing legislation at the state levels for each state first. According to Ross Amato's analysis of the Minnesota Human Rights Act and the Goins versus West Group Incorporated case, the Supreme Court accepted discrimination towards a transgendered individual as lawful because West's enforcement of that policy was likewise grounded on gender. The MHRA provides an exception to the prohibition on sex discrimination for public accommodations, but the MHRA has no similar exception on the prohibition on sex orientation discrimination. If the state were to establish separate legislature specifically expressing the illegality behind transgender discrimination in public arenas like within the workplace and schools, then there would be concrete, substantial evidence supporting a nationally focused court, like the Supreme Court, ruling to determine this discriminatory action illegal. There are several existing successful models of state legislature that other states should also implement in order to eliminate discrimination towards members of the transgender community. According to Elkind, ordinances in New York and San Francisco have officially protected the transgender community by broadening the sex discrimination to include discrimination based on gender identity. Thus, the institution of legislation that is careful in clarifying anything that can be interpreted as permitting discrimination towards transgender members of society is essential in this particular battle. GENDA was recently passed by New York State Assembly and, like the title of this legislation indicates, protects those from discrimination based on their gender expression. GENDA clearly defines the concept of gender identity and distinguishes between two terms that are often mistakenly used interchangeably, gender and sex. The NICLU clarifies that sex refers to the physical characteristics of a person's body, while gender more accurately refers to a person's interior life, one's psychological sense of masculinity and or femininity. The NICLU conveys that their main purpose in creating and advocating for this legislation to pass is to protect those whose physical, sex, and psychological gender do not match. According to the NICLU, even when the courts attempt to relieve individuals of the transgender community from discrimination, they find restriction in the fact that they have to find a clear statutory basis in order to interpret their state law discrimination complaints as legitimately based on sex or disability discrimination. Organizations like the EEOC already take measures to ensure that employers interpret Title VII as protecting the rights of transgendered employees and ensure that they comply with this interpretation. According to Sanders, the EEOC's willingness to protect transgendered employees against discrimination based on their non-conforming gender identity likely has helped create a new, thriving area of employment discrimination law. This is evidenced by an increase in the number of employees who have filed charges under Title VII alleging a sex-based discrimination claim based on transgender or non-conforming gender identity. Members of the transgender community are faced with struggles that many of us cannot even conceive facing, simply because legislation hasn't been implemented or modified to clearly protect these individuals. Many are faced with using a restroom, dressing room, or locker room they don't psychologically identify with. Many are faced with unemployment, termination, and respectively poverty based off of their inability to conform to gender norms. Many are faced with harassment and bullying from other students and even teachers on school campuses. Multiple facets of research focusing on transgender discrimination has particularly emphasized two things. One, establishing legislation that protects the rights of members of the transgender community should first be state-focused. Two, gender discrimination along with sex discrimination should be clearly identified, protected, and defined within legislation for it to clearly protect transgendered individuals from discrimination. Transgendered individuals, like any other human being, find true liberation in the moments they can simply be themselves. Implementing legislation or modifying existing legislation to protect transgendered individuals will shield them from this discrimination that restricts them from liberation.